Professor Noah Feldman. Noah Feldman specializes in constitutional studies with particular emphasis on the relationship between law and religion, constitutional design, and the history of legal theory. Professor Feldman served as a law scholar to Justice David H. Souter of the United States Supreme Court from 1998 and 1999, and Chief Judge Harry C. Edwards of the United States Courts of Appeals for the D.C. Circuit from 1997 to 1998. He received his J.D. from Yale Law School in 1997, serving as book reviews editor of the Yale Law Journal. He's the author of 7 books and hundreds of articles. Please join me in welcoming Professor Feldman.
Thank you very much. Welcome to all of you, especially 1Ls. Can I just see by a show of hands how many 1Ls there are in the room? That's excellent. And it's also super nice to see students here and other people whom I know, so thank you all for coming. The event was billed as having some connection to Constitution Day, and that's why I took the opportunity to propose this topic. I'm working right now, I hope, at the very tail end of an 800-page biography of Madison, with a focus on his ideas. I promise it will never be assigned reading in any course that any of you have to take. But with any luck, it actually would be interesting and entertaining. To give you a sense of how long I've been working on it, Meta Gargia, who's a 1L now, started working on this with me, I think, 2.5 years ago. Now she's at the law school, and the project is still not entirely finished. But that is no blame to her. She has done an enormous amount of very helpful work on it. So my comments are going to be drawn from this ongoing project. I took the topic of Madison, slavery, and the Three-Fifths Compromise because Constitution Day, which is, as you know, a very contemporary, modern invention, is usually described as an opportunity to venerate and honor the Constitution. That's great. The Constitution has many wonderful things about it. I teach constitutional law. I teach First Amendment. I care very much about the Constitution. I'm not here to attack the Constitution. That said, the Constitution came into being in an actual specific context. It was produced, invented, and imagined by real people, James Madison most prominently among them. Those people were humans, and human beings are complicated people who make mistakes and have attitudes and views that differ from place to place and from time to time. Their moral judgments can be in error, their actions can be wrongful, and if it were not so, then the Constitution would be a divine document and not a human one. And although there are some religious groups that are interested in exploring the Constitution as being divinely inspired, I do not adhere to their views. I think the Constitution is a profoundly human production. Brilliant in many ways, profoundly flawed in others. Probably the most famous example of a flaw in the US Constitution, although there are certainly others, is the Three-Fifths Compromise. So what I'm going to do today, with your permission, is I'm going to start with the moment in which the Three-Fifths Compromise was presented in June of 1787 at the Constitutional Convention in Philadelphia. That was, people always talk about the long, hot summer. At this point, the weather was still lovely. But the Three-Fifths Compromise became important as the summer progressed and got hotter and hotter. And I will then, from there, take you back 4 years earlier, still in Philadelphia, to the summer of 1783, and to 2 events that are extremely important in conceptualizing the Three-Fifths Compromise and in trying to make sense of what Madison, James Madison, the most important figure in the history of the Constitution, in my view, the inventor of the Constitution, the person who was called, in the language of the time, the father of the Constitution, thought about slavery. So let's begin with the moment of introduction of the Three-Fifths Compromise into the Constitutional Convention in June of 1787. On the floor of the convention is the question of representation in what will be the lower house of the 2 legislative houses that are being proposed, what will eventually become the House of Representatives. And the question before the delegates is, how should representation be accomplished? One possibility is that representation should be based on some analysis of property in each of the states. Another possibility, one favored by Madison and favored by the delegates who are pushing for a more powerful national government, is that the lower house of the legislature, which, remember, they thought would be the most important part of the most important part of the government. That's why it's in Article 1 of the Constitution. The idea that the executive might be more important would be unimaginable, would have been unimaginable to them. Well, I should rephrase that. Unimaginable to almost all of them. And the idea that the judiciary would be the most important was genuinely unimaginable to any of them. So Anthony Kennedy was not in their minds. those who proposed the possibility of a proportionally elected lower house of Congress, House of Representatives, immediately had to confront the question of how to count the population. And at this moment, Madison, among others, proposed that as a compromise formulation, as between northern states and southern states, enslaved persons, that is to say, people of African origin, brought either they or their parents' parents to the Americas against their will, ought to be counted as 3/5 of a person for purposes of representation, as opposed to free and therefore white, for the most part, citizens who would be counted as full persons. Now, notice the structure of this proposal. Southerners, that is to say slaveholders, of whom Madison was one, ideally would have liked slaves to count as full persons for purposes of representation. They would not have allowed those slaves to vote, needless to say, but by counting slaves as full persons, they would have increased the number of representatives from slaveholding states relative to free states. So actually, the idea of counting slaves as less than full persons served the interests of the northern states, which were themselves free states and therefore had few, were either free or on their way to becoming free, and typically had relatively few slaves. I don't want to overstate the case, by the way. New York, and including New York City, had tens of thousands of slaves in this period. So it's a mistake to imagine that there was no slavery in the North, and a mistake to imagine it wasn't significant. But in relative terms, the slave populations of the states from Virginia, Maryland, and further south dwarfed, percentage-wise, those of the northern states. And indeed, when the proposal was made in the convention, only Elbridge Gerry, who many years later, a very problematic figure, who many years later would become Vice President of the United States, and for our purposes is interesting primarily because he lived about half a mile from here, right here in Cambridge. He also became governor of Massachusetts at one point. He was the only person, when it was first proposed, who opposed this proposal in the convention. And you can guess what his objection was. He said then, and repeated later in the convention, under no circumstances could slaves be represented as persons at all in the count, because that would serve the interests of the North. Now, this is a strange quirk of history. Where did it come from, and what does it say about Madison? To answer that question, let's travel backwards in time almost exactly 4 years to 1783. Madison is again in Philadelphia, and he is now representing Virginia in the Congress of the United States. So as I imagine you all know, before the ratification of the Constitution and its creation, the United States was governed under something called the Articles of Confederation. Under the Articles of Confederation, which was a kind of proto-constitution, please, by all means, come in. Feel free to sit down if you'd like. Hi. It's hard to recognize your former students when they show up in suits. You know, it's very impressive. The question on the table for Congress was how to raise revenue for the government of the United States. As I'm sure you remember from your civics classes, the government of the United States under the Articles of Confederation was extremely weak. And its chief weakness derived from the fact that it was broke. No money, no capacity to act. It had other problems, like lack of capacity to act legally. But that's irrelevant when you don't have any money. Essentially, the states had to consent to pay taxes to the central government. And even calling it the central government is a bit of an overstatement, but to the government of the United States. So in one of the last-ditch attempts to give some heft and capacity to the central government, a proposal was on the floor of Congress, supported by, among others, the Virginia delegation and Madison, that each state should be obligated annually to raise revenue through taxation and send it to the federal government, which to that point it was not obligated to do. The states were not obligated to do. They were trying to raise a princely sum of $1.5 million a year for Congress. It's not a huge amount of money. And the question arose of how to allocate the tax burden across the 13 states. One possibility was to do it on the basis of property. Another possibility was to do it on the basis of population. And the question of population implicated the issue of slavery. At that point in 1783, James Madison introduced into Congress a proposed compromise. And the compromise was this. He estimated, and he later explained that it wasn't based on an exact economic calculus, but on his own analysis of his own experiences in the context of slavery, and I'll talk about his own slaves in just a moment. He estimated that the productive capacity of enslaved persons was roughly 3/5 of the productive capacity in economic terms of free persons. And he proposed that in allocating the burdens of taxation, slaves should be counted in population on a 3/5 basis. Now, if you're quick, you've already noticed how funny this is, because if you're from a slave state, you want to pay less of the overall tax burden. So other Southerners objected and said, we would like slaves to count for nothing in the tax burden, because after all, they're not free persons and we're using population of free persons. Northerners said we would like slaves to count as whole persons for purposes of the tax burden, because after all, they're productive members of the society, or perhaps not members, but productive factors in the society. So notice that the political economy of the 3/5 compromise, as introduced in 1783 in Congress, was 180 degrees flipped from what it was 4 years later in the Constitutional Convention. Right? There's almost total situational determinacy here. When the North wants to pay less taxes, it says slaves should count for 0 in population. When the North wants, on the other hand, to maximize its own representation, its says that slaves should count as 0. The South, for its part, asks for full representation for slaves when it comes to voting, which the slaves will not be allowed to do, and 0 representation for slaves in the population count when it comes to allocating the tax burden. Now, another thing happened in the summer of 1783 that should help us understand the mindset of James Madison in his proposal of the 3/5 compromise. And I want to describe it to you, and it's sort of remarkable. And then from there, I'll tack back to how the 3/5 compromise, first proposed in 1783, ultimately gets adopted in 1787. But I want you to have some sense of the moral stakes for Madison in order to make sense of the practical politics that went into the drafting of the Constitution, and specifically into the 3/5 compromise. So what I'm going to do now is what I would call an exercise in historical analysis with an eye to moral judgment. Now, I think all of you know there's almost nothing harder to do than to engage in sensitive historical analysis coupled with moral judgment of people who lived a long time ago and in different thought worlds than our own. I mean, to be sure, there's an easy way to do it. The easy way to do it is to see morality as universal, and I think that's a good place from which to begin. To assume that universal moral standards apply to everybody always, and to apply our moral judgments to the particular context. That's good moral practice. It's not terribly good historical practice, because you won't understand people in the past very well if you assume that they saw morality the same way we do, because they didn't see it that way. So at least in my view, the first thing you want to do, it should be a two-step process. First, try to reconstruct the thought world of the actor. Then, feel free to impose whatever moral judgment you wish. And of course, there's a third step, which is make practical conclusions on those bases. So let's try to do it in a 3-step process. So let's start with a historical analysis. What did James Madison think about the morality of slavery? Now, context. Madison was born into the arms of a slave. A slave closed Madison's eyes when he died. At no time in his life was Madison without the personal attendance of an enslaved person who functioned as his personal servant. His father owned nearly 200 slaves on their plantation in what came to be called Montpelier in Virginia. And the slavery at Montpelier was not of the tobacco-producing variety, nor of the cotton-producing variety, for geographical and historical reasons. Tobacco farming was characteristic of the tidewater area of Virginia, the area closer to the ocean and the watershed. But in the uplands of Virginia, where Montpelier was, it was not cost-effective to grow tobacco. Similarly, cotton, I'm sure many of you know this, was not the primary crop grown by enslaved persons in the United States until after the invention of an introduction of the cotton gin in the late 18th century, which made the growing of cotton far more economically affordable than it had previously been, economically valuable than it had previously been, and ultimately drove, as much recent historical research has shown, American slavery into a different style of exploitation, in which the nature of exploitation became more and more and more inhumane. One could say that all slavery is inhumane, and of course that's true, but within inhumaneness there are nevertheless degrees. And American slavery became more and more and more inhumane. The forms of torture used became more and more and more extreme as slaveholders in the course of the first half of the 19th century used different techniques to compel their slaves to pick larger and larger and larger amounts of cotton. All that still lay in the future when Madison was born. And on the Montpelier plantation, slaves grew corn and they grew wheat. There was a small but not very good tobacco crop. And there was probably a small but not very good or effective cotton crop. That's the context in which Madison lived. And we happen to have an amazing piece of evidence as to how Madison thought about the question of slavery. Madison, as I say, a slaveholder from birth to death, in the form of a letter of September 8, 1783, so written just a short while after Madison proposed the first Three-Fifths Compromise, written by Madison to his father, James Madison Sr., on the occasion of Madison leaving Philadelphia, finishing his term in Congress, and returning to Montpelier. Now, the context is interesting because Madison had been living in Philadelphia for 3 years serving in Congress. As I mentioned, he was never in his life not attended by an enslaved person. And the particular enslaved person was a man called Billy. We know his name, and we know a fair amount about him from Montpelier archives. Billy had actually been given to Madison by Madison's grandmother as a gift when Madison was a baby. And so Billy was Madison's most valuable piece of property, as well as having been a lifetime companion for Madison. This was someone he had known his whole life. Billy had not gone with Madison to Princeton when he went off to college. Madison had brought a different enslaved African from the plantation, a man called Sawney, who in the long run ended up staying on the plantation for the rest of his life and ended up as an overseer and a significant figure in his own right on the plantation, probably because Billy would have been too young to be brought by Madison with him to Princeton. But again, I'm trying to provide the context. Right? When Madison showed up at Princeton University as an 18-year-old freshman, he did not fend for himself or hire a servant as some of the other rich kids did. He brought Sawney with him, and Sawney slept in the hall outside Madison's room in Nassau Hall. Anyone here went to Princeton? Not even one Princetonian in the room? It's a terrible, terrible showing for Princeton. It's the same building that's there today. You can see the building. Madison slept in his room, and Sawney slept outside for his entire period of 3 years at Princeton. Okay, so Madison faced a quandary in September 1783 over the question of whether to bring Billy back with him from Philadelphia to Montpelier. And this quandary had two parts. There were two motivations that Madison faced. One was legal. This does not appear in the letter, but this is my own partial reconstruction. There was at least some legitimate question about whether it was within Madison's lawful power to compel Billy to return with him from Pennsylvania to Virginia. Why? Well, Pennsylvania had not yet fully abolished slavery, but it was in the process of abolishing slavery. It had declared that all persons born to slaves would be free. That is to say, it hadn't manumitted slaves who were currently being held by people living in Pennsylvania, but it had created a sunset clause, as it were, according to which slavery could not pass from generation to generation within the state. That at least created the possibility of an argument that slavery had been abolished in the state. In a famous case decided in 1771 at the Court of the King's Bench in London, known as Somerset's case, which some of you who've been my students over the years may have read. Well, you had to read it if you were one of my students, so I say may have in the sense that I don't want to presume that everybody does all the readings, but I usually assign it on the first day, so people usually read it. In Somerset's case, the Court of the King's Bench, per Justice Mansfield, most important common law judge ever to have lived, full stop, still to this day, wrote that an enslaved person who had been brought from Jamaica by a British planter to London and had run away from his master before they returned to Jamaica could not be forcibly returned to his master because no positive law of England required him to do so, and because there was no slavery in the United Kingdom. Now, it is not certain, as a matter of practical common law, whether that doctrine would have covered Billy's case. You can immediately think of potential distinguishing arguments. But there was at least a colorable argument, and I'm certain that that must have been one of the risks that Madison knew he faced if he tried to make Billy come back with him to Virginia. But Madison had another consideration, and I'm going to read it to you so you don't have to guess it. This is Madison to his father. On a view of all circumstances, I have judged it most prudent not to force Billy back to Virginia, even if it could be done. Okay? Why? I am persuaded his mind is too thoroughly tainted to be a fit companion for fellow slaves in Virginia. So what's Madison's rationale? The rationale is that Billy has been living in Philadelphia, an increasingly free city with lots of free blacks and other people of color, and he's been living as Madison's manservant. And Billy has been exposed to a world of ideas and social practices and of not equality, but less inequality than would exist in Virginia. And Madison is worried about the effect on the other slaves in Montpelier that Billy would have. So to this point, Madison sounds, as perhaps you'd expect him to sound as a slaveholder, utterly impervious to any interest of Billy's. But there's more. Actually, there's a lot more. Madison then has to explain to his father what he is going to do if he's not going to bring Billy back to Virginia. So what are his options? Anyone? What are his options? He could free Billy. That would be lawful in Pennsylvania. By the way, it wasn't always lawful in every state for slaves to be freed. But he could free Billy. The problem was that Madison, though the oldest son, never made a nickel at any point in his life while his father was alive. He never worked a job. Never trained. He thought about reading for the law, but he didn't really want to become a lawyer. It seemed a little dirty to him. He was the son of a gentleman. He never worked. So all of his money had to come from his father. And he was in the course of this letter describing to his father what he was doing about the person, the human being, who was also simultaneously his most valuable asset. So if he freed Billy, he would have to explain to his father why he needed more money and why he was broke. So he didn't do that. Another option was to sell Billy, but, and here Madison explains, the laws here do not admit of his being sold for more than 7 years. Pennsylvania, as part of its gradual abolition process, had outlawed the sale of slaves. What it did allow, as part of this transition, was to sell a person who was enslaved to you into a 7-year period of indentured servitude. You've probably all heard of indentured servitude, which existed in parallel to slavery and alongside it, and then continued to exist, among other things, throughout the British Empire, even after slavery was abolished. Indentured servitude was a kind of a contract where the person worked for 7 years, typically for low or zero wages, and at the end of that period, but the owner or the master, it's the master technically, was responsible for upkeep of the person, and at the end of 7 years, the person would go free, or of some other specified contractual period of time. So Pennsylvania law allowed Madison to sell his slave without the slave's consent into indentured servitude. This was a kind of halfway compromise mechanism to facilitate and allow slaveholders to get some value for their slaves, even though they couldn't sell them. So that was Madison's second option, to sell Billy into indentured servitude. He certainly would not get as much money for Billy as he would have if he sold him, but it was certainly within the realm of the laws, and Madison clearly thought he could get away with that. There was a third possibility, too, and it afforded Madison the chance to get more money. Can anyone think of what that would be? Yeah?
Send him back to Virginia and then try to sell him in Virginia?
I think it's very close to being right. Remember, there was some legal doubt as to whether you could get him to go back to Virginia. That would have been the natural thing to do, you'd think, bring him back to Virginia and sell him there. But there was a real possibility you might not be able to get him back. But you're on the right track. He could have done something probably illegal, but practically doable. He could have sold Billy to a slaveholder in the Caribbean who would have quietly given him full value and transported Billy outside the country. And at that point, any legal claims that Billy might have had would have been irrelevant because there would have been no one willing to hear them. So this was also in Madison's mind as a possibility. And he chose not to do so, and he had to explain to his father why he chose that, presumably because that would have gotten him more money than he would have gotten if he had simply followed the path of selling Billy into indentured servitude. So I'm going to read you his explanation, and this is, I think, the most astonishing part of the doctrine. I do not expect to get near the worth of him, says Madison. So he won't get as much money for indentured servitude as he would if he sold Billy at full market value as a slave, but cannot think of punishing him by transportation. That is, I cannot consider punishing him by sending him off to the Caribbean, to the West Indies, merely for coveting that liberty for which we have paid the price of so much blood and have proclaimed so often to be the right and worthy pursuit of every human being. Everyone follow what Madison is saying? It's a little shocking. He's explaining to his father that the reason he's not going to gain full value for Billy by selling him to the Caribbean is that he does not imagine it, he cannot think of, he cannot morally imagine punishing Billy by sending him off to the West Indies merely for coveting that liberty, for seeking liberty, for which we have paid the price of so much blood. What's he talking about? Who's the we who paid the price of so much blood for liberty? The American Revolution. We, American patriots, people who fought in the Revolution, have paid the price of blood and have proclaimed so often to be the right and worthy pursuit of every human being. So not only have we fought and bled in the Revolutionary War for our freedom, but we have declared many times that every human being, Madison's terms, not ours, has the right, Madison's terms, not mine, of being free, of liberty. Again, Madison's word. So, I mean, it kind of boggles the mind. In this letter, Madison is saying to his father that he's going to sell Billy into indentured servitude rather than selling him for full value to the Caribbean because it seems immoral to sell Billy to the West Indies for trying to exercise the human right of liberty, which every human being is entitled to and for which we fought. Everyone with me? So what can we say, still in the level of historical analysis, about Madison's moral thinking here? This is before we get to our own judgment. We're still trying to figure out Madison's moral thought here. Well, I think among other things, we can say that Madison did not, unlike, say, Thomas Jefferson, think that when it came to the pursuit of liberty, people of African descent were any less equal than people of European descent. He does not say here, as Jefferson sometimes did, that people of African descent are inferior in any genetic or moral way. He thinks that all human beings, and he's clearly including Billy within that category, have a fundamental human right, or right as a human being, which is a human right, to the pursuit of liberty. And he thinks the revolution was fought for that purpose. So he is aware of the immorality of slavery. Indeed, he's focusing on and making an argument to his father to help explain why he's about to lose all this money, that it would be immoral to send Billy into a deeper form of slavery than he's already in, even though he is going to send him into indentured servitude. Now, this is not accompanying any request for Madison's father to free any other slaves. It's not accompanying a statement he's going to free Billy. The father never thought of freeing other slaves, and Madison never did. Not that it was completely unimaginable, incidentally. Madison's eventual wife, Dolly Madison, he wouldn't meet her for some years after this, was from a Virginia family of Quakers, members of the Society of Friends, and her father was one of those who reached the conscientious judgment in Virginia that he ought to sell his slaves or free them. It was unlawful for him to free his slaves in Virginia, so he took the family to, you guessed it, Philadelphia and freed his slaves there. And that was roughly around this same time. So it's not that it was unimaginable in Madison's Virginia to realize that slavery was immoral and to free your slaves. It was just so extreme as to be thought to be a kind of madness. And indeed, Dolly Madison's father, after he did this, then took the money, such money as he had, he freed his slaves without getting value for them, invested it in the stock market, lost it all, and left his family completely impoverished. I mean, there's no direct connection between those things, except that he gave up what was his most valuable asset. And then went spectacularly broke very quickly thereafter. I mention this merely as Madison didn't know the people at the time, these people at the time. I'm mentioning it just to show you a broader sense of context. It was possible not only to imagine the immorality of slavery, as Madison clearly does, but to act on it. It was just an outlying thing to do. So Madison understands the immorality of slavery, and in the same breath in which he's expressing that notion, he's going on to sell Billy into indentured servitude. I think it's hard to imagine, if you sort of said to yourself, I wish I could find a historical document that would help capture how Madison thought about slavery. You couldn't make up a document as clarifying as this, because it captures the depth of the contradiction in his thinking. He is simultaneously open to the notion that slavery is immoral and that everyone has a human right to be free, and utterly unwilling to consider in more than a very glancing way any deviation from his own self-interest. Right? Notice the combination here. He has a moral feeling, but self-interest obviously dwarfs it for him. Clearly dwarfs it for him. He's willing to pay some price for his moral beliefs. After all, he's not going to get as much money for Billy as he might have done. But there's a clear, identifiable, I almost want to say quantifiable, in this case, value that he places upon his moral judgment. It's worth the difference between full value of selling Billy to the Caribbean and indentured servitude. That's the value he's willing to pay for his beliefs. But it's not worth the difference between the value of the indentured servitude sale and no sale at all. Right? I mean, one experience of being a 1L is to encounter a wide range of legal contexts in which sentiments and other intangibles get measured by money in the law. That's one of the weirdest things of being a 1L, to encounter the brutality with which the law does this. And often we have to accept that it's a very approximate process, it's very difficult to measure. Not so here. You can put a monetary value on Madison's morality here for himself. Now, tack back from all of this to the 3/5 Compromise, as he introduces it just a few months before this in 1783, and as he reintroduces it at the Constitutional Convention in 1787. What's going on? And what does it mean for the Constitution? Well, what's going on is that Madison is engaged in precisely the same form of self-contradictory thinking. He believes at all stages that slavery in the long run should be abolished. Indeed, much later in his life, he'll become the president of the American Colonization Society, which is an organization devoted to achieving the freedom of American slaves, probably by purchasing them from their owners, transporting them to Africa. Liberia is the place where the colonization process began, so that they could live freely, but live freely in Liberia, not in America. This is based on the theory that Madison and others held very firmly at the time, which was that once freed, the descendants of slaves would be unwilling to live in peace with white people, and that white people would be unwilling to live in peace with them. And the conclusion was to colonize a section of Africa. And as many of you know, this is part of the very complex history that led to the existence of modern Liberia. So Madison at all times in his life believed that slavery ought to be abolished someday, somehow, by some means, just not now. Simultaneously, at no stage was Madison in his personal life or in his professional life, which was the creation of the Constitution, that's his most important professional accomplishment, willing to do anything other than act according to the broader interest of white Americans, of whom he obviously included himself. So the Three-Fifths Compromise, in both of its forms, both in its initial form, where Southerners are saying ideally blacks would get zero representation, and in its constitutional form where Southerners are saying that ideally blacks would have full representation without the vote, in both of these forms, the Three-Fifths Compromise stands for the transcendent value for Madison of pragmatism in getting to a deal over and above the moral demands of the liberty of enslaved people. That's the whole ball of wax. And over the course of the summer of 1787, it gradually becomes clearer and clearer that without something like the Three-Fifths Compromise, there won't be a constitution. This is a story that can be told at much greater length, and in fact, I do tell it at much greater length in the chapter. But at the beginning of the summer, the biggest divide is the divide between small states and big states at the Constitutional Convention. But by the end of the summer, and you can see this happening, the divide has shifted, and now it's a divide between free states and slave states. Northern and southern states, a sectional divide, which of course will then go on to be the divide that breaks the Constitution at the time of the Civil War. So by the end of the summer of 1787, the delegates behind closed doors in Philadelphia have already discussed the possibility of a North-South Civil War. They don't even dream of this the day they start. By the time they're done, they have realized the divergence of interest and the possibility of an actual sectional conflict that turns into war, and they actually overtly discuss this. As that debate continues, the Three-Fifths Compromise goes from being something introduced early on as a simple solution, in which Madison is saying, hey, we had a deal we made about this before. Our interests are opposite now, but let's keep the same numbers. And everyone else says, okay, let's keep the deal. Why? Because we already introduced it on that other occasion. And it's flipped here. So no one says, well, let's make it 2/5. They don't haggle. Why don't they haggle? Because they already haggled about it. And there's a great value in a negotiation, and that's, after all, what the Constitutional Convention was, an epically complex negotiation. A great value in taking a term from the past that's worked and plonging it in and saying we're going to use it for these purposes. Pragmatism, 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 and here it's not just Madison, it's now everybody in the convention. Southerners and Northerners alike. Everyone is accepting this compromise, and by the end of the summer they know that without some version of this compromise, no constitution. In that sense, then, I think it's fair to say historically that Madison's own conception of the relationship between the liberty interests of enslaved people and the larger pragmatic interests of keeping the Union together and his personal self-interest, which are not so totally distant, was adopted by the convention as a whole. Then it was ratified by we the people of the United States, obviously not counting enslaved people. That is to say, not counting in the we the people. So, what are we to make of all of this? Now, that's the end of my historical analysis. I just want to say a word or two about the moral analysis, and then I want to open up for a brief conversation, and then I'll let you all go to class or get something to drink, because you've had pizza lunch and you haven't had drinks, and you probably, if I'm thirsty, you're probably much thirstier. So what is one to do with this legacy? Well, the first thing is to understand it. To be aware of the Constitution and the people who created the Constitution as having lived in a particular time and a place, and having had a particular set of attitudes towards slavery. Would they be more morally admirable if they had utterly been unwilling to acknowledge that slavery was a violation of human rights? Maybe, you can say that. You know, there's something slightly less horrible about a person who acts immorally without knowing it than someone who acts immorally while knowing they're acting immorally. It's a plausible argument. I mean, on the other hand, you could also say that they should be given some moral credit for at least their recognition. And furthermore, some of them said explicitly in the convention that they hoped for eventual abolition. Others, of course, said, above all, the Constitution must guarantee that there never be eventual abolition. Both of those viewpoints were expressed in the convention, and the compromise is not just the 3/5 clause, but also the Fugitive Slave Clause, are forms of compromise around that issue. Incomplete solutions to the issue. So one more analysis would be to weigh those questions. Is it better to be Jefferson or Madison? Jefferson is someone who had children who were themselves enslaved, right? Because he had them with Sally Hemings, who was an enslaved woman. She was the half-sister of his late wife. They looked extremely similar. It seems, according to Professor Annette Gordon-Reed, who won every prize that there is in North America for her book, which I urge you to read, The Hemingses of Monticello. She shows very convincingly that Madison's romantic and sexual relationship, romantic is a debatable term, and she discusses whether it's a term that one could use, so I'm not either using it or not using it. You should look at her book for that. But his very long-term sexual relationship that produced multiple children with Sally Hemings did not begin until after his wife, well after his wife Martha had died. So here's Jefferson, right? Several children who are African American. He did actually manage to free his own children, though he never freed Sally Hemings, and Annette writes at great length about that question. Said many times, not only in the Notes on Virginia, but also in private conversations with people who wrote it down, that he was convinced of the inferiority, the natural inferiority of people of African descent. Madison recorded not only here, but also in some of the conversations with people who had just come from visiting Jefferson at Monticello and went to see him in Montpelier, had a different view and believed in the equality of all people, including people of African descent, and never freed his slaves. And as far as it's possible to ascertain, had no sexual liaisons with the enslaved people on his plantation or anywhere else, as far as it's possible to ascertain. So, one can engage in the very complicated and difficult process of trying to judge which is morally superior, which is morally inferior, and that's a genuine debate that one can have. What about the Constitution as a whole? What are we to make of a Constitution that could not have come into existence without this profoundly immoral compromise on the question of the liberty of people of African origin? What are we to make of that? And what do we make of that on Constitution Day? And what do we make of that when we study the Constitution? Well, Frederick Douglass was of two views about this at two different stages of his career, and I'll just mention these to you. Early in his life, Douglass was sympathetic to the views of the abolitionist William Lloyd Garrison, who thought that the Constitution was a covenant with hell. Garrison thought the Constitution was fundamentally flawed by the original sin of slavery, and the only solution was to abolish it, the whole Constitution. And early in his career, Douglass agreed with Garrison. Later in his career, Douglass shifted, and instead he came to argue that the best way to interpret the Constitution was as not enshrining slavery. That is, against his own knowledge of what had actually happened at the convention, he argued for an interpretation of the Constitution that would cleanse it of slavery. He said, look, the framers never used the word slavery. True, because they were embarrassed about their compromise. That they never said that slavery is permanently enshrined. True, because they were compromising. That they allowed for an end to the slave trade 20 years after the ratification of the Constitution. Also true. Of course, you could emphasize the fact that they preserved it for 20 years, but they also allowed for it to sunset. And Douglass made a series of arguments according to which the Constitution ought to be interpreted more expansively and as a liberatory document. So that's another strategy for making sense of the Constitution. It's to see the Constitution as a document in evolution, to focus on its subsequent transformation through the 14th Amendment and other amendments, and the 13th, 14th, and 15th Amendments, and to see the Constitution in terms of its capacity to evolve and in terms of its broader capacity to stand for principles that one does like, rather than focusing on the features that were profoundly immoral at the outset. It's not for me to tell you which of these approaches to adopt, and there may be still other approaches that can be followed. But what I think is incumbent on me to tell you, and this is, I think, is a useful thing for you going forward in your careers, especially for those of you who are 1Ls, is to make sure you go through these steps when you deal with the documents of the law. Statutes, the Constitution, judicial opinions, and the like. Right? Evaluate them, understand the real-world compromises that took place, make your analysis, make your moral judgment. Then ask yourself the question of how to interact with these sources going forward for yourself. But if you go through that three-step process, you'll be empowered, I think, to form conclusions and to make judgments that will satisfy you morally. The easiest thing to have happen in law school is to think that because law and morals, according to some theories, can be separated, that you never have to make a moral judgment on the law. That's wrong. That's just flatly wrong. Even if you believe that law and morality can be separated, you still have to believe that morality can be used to judge the law. No positivist who believes in the separation of law and morals has ever denied that, and indeed some have argued that the whole reason to separate law and morals is not to make the mistake of thinking that whatever the law is moral. So that's my wish for Constitution Day. Not to whitewash the past, to be open to Madison's genius as well as his limits, to see the immorality of slavery in its context, to judge it through the lens of our own morals, while simultaneously seeing it through the lens of Madison's morals and the deep contradiction that ran through them. Thanks, and we have time for a few questions.